We welcome everyone to today's hearing on legislative reforms to end lawfare. I will now recognize myself for an opening statement. Welcome. We are here today to discuss potential legislative reforms to end lawfare by state and local prosecutors. Rather than debate political opponents on substance, my colleagues on the other side of the aisle thought they could win the 2024 election through the use of partisan lawfare tactics. Lawfare has been defined as, quote, the strategic use of legal proceedings to intimidate or hinder an opponent, end quote. Lawfare violates the fundamental mission of prosecutors. Prosecutors' job is to do justice. As a former assistant United States attorney, I made it my duty to uphold the law with fairness on those I charged, making sure their civil liberties were kept intact. Additionally, when I was a prosecutor, I methodically ensured the cases that were brought before me would not fall to political pressure or succumb to outside influence, especially to score cheap political points. Every American deserves to have a justice system that is divorced from the political whims of elected office holders, political parties, and personal vendettas. In their political pursuit of President Trump, however, we saw state and local prosecutors abuse professional norms in favor of achieving indictments against their target. Prior to the 2024 election, President Trump was criminally indicted 4 times. Let's take a quick look at the state and local lawsuits brought against President Trump. First up, Fulton County, Georgia District Attorney Fani Willis's 41-count indictment against 19 defendants, which included President Trump, his attorneys, his former White House chief of staff, and a former Justice Department official. The politicized nature of this prosecution is hard to ignore. A mere 4 days before the indictment, DA Willis launched a campaign fundraising website highlighting her investigation into President Trump. And though DA Willis's investigation was first reported in February of 2021, it was not until President Trump announced his candidacy that she brought charges. And later, DA Willis requested that the trial begin on March 4th, 2024, the day before Super Tuesday and just 8 days before the Georgia presidential primary. To charge President Trump and his co-defendants, DA Willis used a broad interpretation of Georgia's RICO law, which is intended to be used to prosecute criminal enterprises that infiltrate legitimate businesses and use interstate commerce. For background, RICO statutes are used to prosecute organized crime mob bosses, street gang leaders, and other crime syndicate heads, not typically elected office holders on absurd charges. Prior to indicting President Trump, she coordinated with special counsel Jack Smith and the partisan January 6th committee. Her lead prosecutor, Nathan Wade, met with the Biden-Harris White House on multiple occasions. Then we have New York Attorney General Letitia James, who has made her disdain for President Trump well known. When she ran for New York Attorney General, she made many personal attacks against President Trump, calling him things like con man, carnival barker, and even an illegitimate president. As soon as she took office, AG James began investigating President Trump. In September 2022, she sued the president, alleging that he and his company had committed fraud to inflate the value of his properties. Now let's turn to Manhattan District Attorney Alvin Bragg, who indicted President Trump with 34 counts of falsifying business records, which was tied to an unknown federal crime which aggravated the charges to felonies. The Manhattan District Attorney's Office had been investigating President Trump since 2018. But it wasn't until after President Trump announced he was running for president in late 2022 that Bragg elected to resurrect the zombie case against President Trump. And who did he bring on to help his politicized investigation? Bragg hired senior Biden-Harris Justice Department official Michael Colangelo to jumpstart his office's investigation of President Trump, reportedly due to Colangelo's, quote, history of taking on Donald J. Trump and his family business, end quote, while working for the New York Attorney General's office. One should be equally concerned if it were a Republican district attorney engaging in this conduct toward a former Democrat president, cabinet secretary, or White House official. These prosecutions are precisely what former Attorney General Robert Jackson warned us about. Attorney General Jackson warned about the most dangerous power of the prosecutor, quote, that he will pick people that he thinks he should get rather than pick cases that need to be prosecuted. It is here that law enforcement becomes personal, and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or being personally obnoxious to or in the way of the prosecutor himself, end quote. And that is precisely what we have here. This is why Congress must address Democrats' lawfare efforts by popularly elected state and local prosecutors against federal officials. In fact, many of my Democratic colleagues on this committee are vocal proponents of a fairer criminal justice system, calling an end to perceived needless instances of overzealous prosecution, wrongful arrest, and detention, and limiting incarceration overall. What better way to achieve these goals than engaging in this hearing to uncover possible missteps by state and local justice systems and ushering legislation to rectify these glaring blind spots? Current law does not adequately protect federal officials from rogue state and local attorneys who stack unwarranted charges against their political opponents. Under current law, the option to remove civil or criminal cases from a state court to a federal court is limited to federal agency officials and legislative and judicial officers. Our colleague on the Judiciary Committee, Congressman Fry, has a bill that would fix this problem. The Promptly Ending Political Prosecutions and Executive Retaliation Act of 2025 is designed to protect our nation's leaders from lawfare tactics. This bill gives both current and former presidents of either party, vice presidents, and federal officials the ability to remove civil and criminal cases against them from a state court to a federal district court. The bill also codifies the immunity recognized by the U.S. Supreme Court for official acts carried out by a federal official. This bill should not be misconstrued as a get-out-of-jail-free card. Far from it. It should be an opportunity for individuals to have a shot of non-politicized due process experience. Make no mistake, if a federal official were to commit theft, fraud, assault, or other crime, they should be held accountable regardless of political party or policy views. This introduced bill should be welcomed by both parties, as no individual acting within their duties should be sought after because of whom they work for or their political leanings. I'm looking forward to discussing that particular bill, as well as the need for legislative fixes in this space today. I want to thank all of our witnesses for being here today. We look forward to your testimony and the robust conversation on how we can move forward and fix this problem. I'll now recognize myself for 5 minutes for questions. One thing that was raised earlier was a little bit about how, 15 years ago, the DOJ may have gotten a little bit politicized. I think, Mr. Terwilliger, you were referencing that. I served in the Department of Justice about 15 years ago, right on the number, when I was a special assistant United States attorney. And one thing that I would note, Jack Smith has been at the center of a lot of these issues and debates in terms of lawfare. Obviously, that's in the federal context. When he entered his role as special counsel, Smith had already had a pattern of targeting Republican politicians. For example, in 2013, when he served as the head of DOJ's Public Integrity Section, Jack Smith encouraged his subordinates to contact IRS official Lois Lerner to discuss how the federal government could bring charges against conservative nonprofit organizations. Was that a depoliticized Department of Justice, Mr. Terwilliger?
No, sir, and you've hit right on it. When you just use your common sense to look at what's happened. When you see some of the former prosecutors that were involved in some of these cases showing up as commentators on MSNBC, spouting political rhetoric, you don't have to be a genius to figure out what happened at the department.
It's not the only example, right? We can go down Lois Lerner, we can go down a whole bunch of different possibilities. How about Eric Holder himself with Fast and Furious? It wasn't like the Department of Justice was, looking to go dive deeply into what was going on with respect to specifically what Eric Holder did.
I love that example, Mr. Roy, because can you imagine if Pam Bondi stood up today and described herself as Donald Trump's wingman, as Eric Holder described himself for President Obama?
Well, you can see why I was only a special assistant U.S. attorney for a couple of years during the Holder era and decided to move on and work for Governor Perry down in Austin. Let me tell you something. Let me ask you this question. You cited the two members of the 11th Circuit panel, right? And they concurred in the result, but they raised this issue. Is that right?
That's correct.
And the issue they raised, I'm quoting, is, quote, in short, foreclosing removal when states prosecute former federal officers simply for performing their official duties can allow a rogue state's weaponization of the prosecution power to go unchecked and fester, end quote. Is that a correct quotation?
Correct. Yes, sir.
You share that concern, do you not?
Absolutely.
Could you just describe a little bit? I mean, we've discussed it at some length here, but as we take up this legislation, at the heart of it lies the question that was going on here in the exchange between, I think, the ranking member and Professor Pesky and some others about the job and the nature of the job. And so if you're in the case of your client, the chief of staff to the President of the United States, and the President of the United States asks you to set up a call, and there is the inherent blend between official and political in what we do, right? And so something is, something we seem as official, you're the chief of staff, you're working through it, and then there's some political questions that come up. So how is it that we can proceed if we don't have clarity with respect to the actual job, with respect to how you were describing that earlier? Could you expand on that a little bit?
Well, I would submit to you, Mr. Roy, that there is absolute clarity in terms of that job. In 1939, Congress passed a statute and said, okay, we're authorizing assistance to the president. Never existed before. Before that, they had always been borrowed from agencies and brought into the White House. Presidential assistants were authorized by Congress, and Congress said their duties shall, quote, be as prescribed by the president. So when the president asks you to make a phone call, you're acting within the scope of your office.
Do you think it would be good for the country were it to be true that, for example, some, I don't know, pretty aggressive district attorneys in South Texas, or maybe in working coordination with the Attorney General of Texas, decided to say, you know what, we think that the actions of, maybe it was DH Secretary Mayorkas, maybe it was the Attorney General, maybe their actions in leaving the borders wide open to endanger Texans was actually in violation of law. Maybe they should be prosecuted under Texas law because of what they did to the people of the state of Texas, the people in my district who are no longer alive, the people who have suffered the $11 billion we've had to spend in Texas. Do you think it's a good direction for us to go to have it such that state DAs and state attorneys general can then go after officials in their carrying out their official capacity and the ranges around that official capacity? Do you think that's a good thing or a bad thing? And do you think it's important for us to clarify that law?
It's a terrible thing to go in that direction, but that's the direction it's going. And it is inevitable that the worm will turn and there will be Democrat officials of political appointees who will be subject of just the kind of action you describe. This is a place for Congress to assert itself and say, just as the title of this statute says, we want to try to end this kind of lawfare. We may not be able to do it completely. We may not be able to do it perfectly, but it's a very, very important step.